good afternoon. I think we're going to put the slides on now. And Mr. Piffaut could not come today, and I will give the presentation on his behalf. I work in the same unit, of whom he's the head of unit, so we deal with antitrust in pharma and health services. Okay, so first, starting with an outline of the presentation today, what I will speak of is just give first a brief introduction on patent settlements in general and recent enforcement that we have had. Afterwards, I will mention the sector inquiry and the further monitoring exercise. Okay. And the further monitoring exercises that we have done in the Commission. And afterwards, I will discuss more at length the recent cases, in particular the Commission decision that we issued in June this year in Lundbeck with some guidance case law for assessing reverse payment settlements. Afterwards, I'll mention, I just have one slide on the US Supreme Court in Actavis. As Mr. Stroh said, I think that it will be discussed more at length by other speakers. And finally, I will just mention also a note on the statement of objections in the Perrin-Depril survey case. Settlements take place on a bilateral level, and they allow to save public resources, reduce uncertainty, and they are generally regarded as positive for society. However, I'll explain later during my presentation that there are some types of settlement agreements which are likely to catch the Commission's attention, and this will depend, of course, on the specific facts of the case, and I will give an overview of that. So, recent enforcement in this area. I mentioned already the activist decision of the US Supreme Court. Also, you may have heard of the Office of Fair Trading, who also issued a statement of objections in April this year in the paroxetine case. And the Commission's enforcement in this area, we have had the Lundbeck decision, which I mentioned, and the Perrin-Depril case. These are so-called pay-for-delay cases that I will explain what we mean by that term actually in the next slide. The second, development in this area, what we do in the Commission, it's not exactly enforcement, it's really monitoring exercises, where we gather data from the industry on the settlements they have concluded, and we analyze them and categorize them. You will see the results of our latest monitoring report in the following slides. So patent settlements, okay, they are generally positive for society, as I just said. And there are some of them, however, that may appear potentially problematic from a competition law perspective. We have first the so-called reverse payment settlement agreements. This is a scenario in which the originator and the generic companies strike a deal in which the originator pays or transfers value to the generic company in exchange for certain limitations on entry in particular. We also have restrictions. These are other settlements which may appear problematic from our perspective, are settlements which entail restrictions beyond the exclusionary zone of the scope of the patent. This can be, for example, the material scope or the temporal scope of the patent. For example, if you have a settlement which goes beyond patent expiry. And finally, there are settlements which concern sham patents. These are settlements in which the patentee knows that actually its patent does not meet the patentability criteria. So turning now to the monitoring report. Why do we monitor settlements agreements first? First, to better understand the use of patent settlements in the European pharma sector. Also intensify control of reverse payment settlement agreements. And this is, let's say, it has a background in the pharmaceutical sector inquiry that the Commission did, and the final report was issued in 2009. There were a few concerns after conducting this sector inquiry, and this is why the Commission now enforces cases and looks specifically at practices which may delay generic entry or, let's say, go against innovation. So the latest monitoring exercise that we did, I think actually I saw it in the package that is prepared for you here. So this was the one that we published in July 2012. And what we actually do in the monitoring exercises is that we ask companies to provide the settlement agreements, we ask for limited background information, and then we categorize all this. These are some general statistics, a graph of development over time. In the sector inquiry, we asked companies to submit their patent settlements from the year 2000 onwards until 2007. So the first figures are from the sector inquiry, and then it's monitoring exercises which provided the following data. And we see on the graph here, the black column, you see the total number of settlements all over the years, which have increased. So overall, the number of patent settlements which are with relevance for the European Union have increased significantly since the year 2000. In the latest report, so we received 120 settlement agreements which were concluded between originator and generic companies. So this is a categorization that we have here on whether the settlement limits generic entry, and when it limits generic entry, does it also involve a value transfer from the originator company? Value transfer, it's, let's say, what can it mean? It's the most straightforward that we have is a payment, direct monetary transfer from the originator company. We could also have a license that is considered as a value transfer, and also distribution and supply agreements that are done between the originator and the generic company. The next slide is actually a graph showing also over time the development of these different categories I just mentioned now. So the A category that you see on the left-hand side of each year, and then the B2 category on the right-hand side in black, on the black graph. So we see that there is a stabilization of B2 with a slight increase actually in 2011, and the ones that don't limit generic entry, the A category, actually remains at quite high level. What were the conclusions from this monitoring? So we have a significant increase in the number of patent settlements in the European Union since the sector inquiry, stabilization of possibly problematic B2 category ones, and the fact that the Commission has been, let's say, attentive to patent settlements does not force companies to abstain from settlements and litigate ad infinitum. You see that settlements continue to be concluded in different ways. We categorize them in different ways, but they still continue, and the industry is not left without any means to settle their dispute. After giving this overview of the latest monitoring exercise, I would like to discuss our enforcement after the sector inquiry. What have we done? So we mentioned earlier we have a Lundbeck decision. We had open proceedings against Lundbeck and several other companies in 2010. We also opened proceedings in the Perrine de Preux-Servier case 1 year before, and also Cephalon and Teva, which is still at the stage of opening of proceedings. No SO was issued yet. We have a decision, and this is something that I will discuss just right now on the Lundbeck case. This is the only one in Perrine de Preux-Servier. We are also at the statement of objections stage since July 2012. So before discussing the specific cases, I would just like to recall certain case law that provides guidance for assessing reverse payment settlements. And actually, just to see, you know, as Mr. Strowell, Professor Strowell mentioned before, we are in an area between IP and competition. So can competition intervene in this area of patent settlements? First, the Central Farm case. This is a case by the European Court of Justice, which ruled on the relationship between IP rights and competition law. And it held that the conditions under which IP rights may be exercised may fall within the prohibitions of Article 101, whenever the exercise of such a right appears to be the object, the means, or the consequences of an agreement. The second case that I mentioned on the slide is Bayer-Suhlhofer. In this case, the ECJ clarified that patent settlement agreements, like any other agreements, are subject to competition law. We have an excerpt from this case that you could read. It's paragraph 15 of the judgment, which says, in its prohibition of certain agreements between undertakings, Article 1011 makes no distinction between agreements whose purpose is to put an end to litigation and those that are concluded with other aims in mind. The third case I mentioned here is windsurfing. In this case, the ECJ held that although the Commission is not competent to determine the scope of a patent, it is still the case that it may not refrain from all action when the scope of the patent is relevant for the purposes of determining whether there has been an infringement of EU competition law. So this suggests all these first three cases that I mentioned here, that whenever companies conclude a settlement agreement, they need to respect competition law, although a patent may be involved in this dispute. And finally, the last judgment is Irish beef. This concerns an agreement between competitors in the Irish beef processing industry. It involved the major players of this industry, which agreed to pay the players who would voluntarily leave the industry, and in return for that payment, the players would agree to decommission their plants, refrain from using the lands they were using, and sign a 2-year non-compete clause with regard to processing anywhere in Ireland. So the ECJ in this case considered that the reduction of overcapacity in the market, which is what the aim was, through an agreement and by way of rent sharing between the ones who left the market and the ones who stayed on the market, amounted to a restriction by object. This is the last case I mentioned, as you see, is nothing related to a patent, but shows a scheme made between competitors on a given market. So we have the case law guiding us, and now I turn to what exactly happened in the Lundbeck case. Sorry, I've been made you waiting for a long time for the facts of the case. So we have here the citalopram molecule is concerned by this case. It was Lundbeck is a, sorry, just to mention, Lundbeck is a Danish pharmaceutical company. It's the originator company, meaning that it is the one who held the patent for the molecule, the active ingredient. So citalopram was an antidepressant and Lundbeck's best-selling medicine at the time. After the basic patent for the citalopram molecule had expired, it held still a related number of process patents which provided for more limited protection. So producers of cheaper generic versions of citalopram had the possibility to enter the market, and indeed one of them had actually started selling its product, and several other producers were making serious preparations to do so. But instead of competing, the generic producers agreed with Lundbeck, and this was in 2002, not to enter the market in return for substantial payments and other inducements from Lundbeck amounting to tens of millions of euros. We see here on the slide, I've mentioned something that we had also in the press release, internal documents that refer to a club being formed and a pile of dollars to be shared among the participants. So in fact, Lundbeck paid significant lump sums, purchased also the generic stock that they had produced only to destroy it at the end, and it offered guaranteed profits in a distribution agreement. So how did we assess the case? We looked at the economic and legal context, the content and actual objectives of the agreement, and also the subjective intentions of the parties. And the Commission looked in particular at the following aspects. So potential competition between the two companies. There were several agreements in this case, but of course each one of them is assessed. So potential competition between the originator and the generic. And the investigation showed that the generic producers in question had envisaged viable routes to the market, They had, for instance, considered challenging or circumventing some of Lundbeck's process patents, and this demonstrated that the generic and the originator producers were indeed potential competitors. The second point we looked at was the fact that the generic producer had committed itself in the agreement to limit its independent efforts to enter the market during the period for the duration of the agreement. And the third point was the value transfer that was transferred from the originator to the generic, which substantially reduced the incentives of the generic undertaking to independently pursue its efforts to enter the European market. It was also found that the value transfer I just spoke about took into consideration the turnover or the profit that the generic company expected to earn if it had successfully entered the market. We also looked at the fact that Lundbeck could not have obtained the limitations on entry to enforcement of its process patents. As a matter of fact, the agreements imposed obligations on the generic which went beyond the rights of holders of the process patent. And finally, the agreements contained no commitment from Lundbeck to refrain from infringement proceedings if the generic undertaking entered the market with citalopram after expiry of the agreement. Following this analysis, the Commission concluded that there had been a restriction by object because of the agreements concluded and the precise factual circumstances of this case. However, of course, the finding of a restriction by object gives the possibility to the parties to claim efficiencies under Article 101.3. This was done, but the criteria of Article 101.3 were not met by the claimed deficiencies. So the Commission imposed the fines on the undertakings, and as Professor Stroll said earlier, our Commission decision is now under appeal before the General Court. Having this in mind, I would just like to touch upon the Actavis decision of the US Supreme Court that I mentioned earlier. What happened there? So there was divergences between the different district courts in the US. Some of them had opted for the scope of the patent test, which said that absent sham litigation or fraud in obtaining the patent, a reverse payment settlement is immune from antitrust attack so long as its anti-competitive effects fall within the scope of the exclusionary potential of the patent. This was one side. Other circuits adopted a different view of the matter, and they said that a reverse payment settlement was in itself a prima facie restraint of trade, so presumptively unlawful. In the Actavis decision, the Supreme Court pronounced itself because of these divergences, so it accepted to pronounce itself and rejected both the scope of the patent test and the presumption of unlawfulness, and actually told the courts which were going to analyze, the lower courts which were going to analyze settlement agreements from now on, to perform a rule of reason. And one of the indications also it gave centered around the size of the payment that was made by the originator to the generic company, and mentioned that actually the size of the payment is a strong indication of power on the patentee, and also that a large unexplained payment actually can be a sign that the patent is not as strong, if I remember correctly. I will not say more about the US situation, except that the recent court judgment, a Massachusetts Judge Young, applied the Supreme Court standards actually to a reverse payment settlement, but I will not mention more. I think this will be discussed as well later on. And finally, the Perrine-Dupriol-Servier case that I would like to mention after presenting Lundbeck at length, which I cannot do in Servier since it is an ongoing case. But just I would like to mention what we had and our preliminary view. So we have agreements here between the French pharma company Servier and several generic competitors, which may have hindered the entry of generic mirindopril in the EEA markets. We also had patent acquisitions by Servier that could shut out competitors from the market. These deals between the agreements featured substantial payments from Servier to the generic companies. And these companies abstained from entering the market with their generic product and from further challenging Servier's patents. We also concluded that there was a comprehensive strategy by Servier to prevent generic market entry when end of its patent protection was imminent. So what was the consumer harm from this and from the previous cases, that there was a delay in generic entry when we have potential competitors trying to enter the market and could not enter the market as a result of the settlement agreement, and the prices therefore for the product of the originator remain the same and remain high. So yeah, I will go, thank you, and I wanted to say that, so just to, let's say, give a conclusion and say that we are in an area which is, let's say, tense IP competition, but seeing the case law of the European Court of Justice that I mentioned earlier, we have IPRs which are very important for innovation. However, we know that when there is also competition which should be involved, and there the companies have to be careful when they conclude patent settlements that they are not immune from competition law scrutiny.